All right, so in this case reading video, we're going to be looking at the Esanda case, which is another penalties case, okay? Except this one has a liquidated damages clause actually in it. Unlike the other case that we did in Ringrow, where it was the clause involved the transfer of property back to BP. So this one's a bit more of a traditional example. Okay, I'm going to share my PowerPoint with you guys now. All right, quite like this PowerPoint too. I found this, a new template for using this one again. All right, let's get going. Okay, so in this case, there was a hire purchase agreement between Esanda, which is a finance company, and Plessnig, who was the hirer, and Plessnig bought a prime mover. Okay. In the agreement between the parties, one of the clauses said that if the hirer, so here Plessnig, failed to pay for a 7-day period, so if they were 7 days late on a payment, Esanda could repossess those goods and terminate the contract and then recover as liquidated damages the recoverable amount defined in Clause 5. Which included, the monies owed, etc. So there was a couple of different things that clause involved in terms of how much they could get as liquidated damages. Now, under the agreement, Plessnig had to pay back Esanda 36 payments, okay, and it failed to make a number of payments in a row. And then Esanda terminated the agreement, repossessed the vehicle, and in the process, the contract was terminated, and then they demanded that liquidated sum, which involved those things in the dot point above. So all monies owed, the value of goods, rebate of charges, etc. And I think it worked out as around $10,000, although you may want to check that in the case. Don't quote me on that one. Okay, and yeah, I'll just leave that there. All right. So in terms of the issue here, the issue was whether Clause 5 was a penalty or a liquidated sum, okay? So whether that clause was essentially enforceable. And in looking at that or in resolving that issue, what we're focusing on is whether the amount specified was out of all proportion, that is disproportionate, / extravagant / exorbitant / unconscionable to the loss suffered. Okay, so there's that principle that comes through really strongly in the other case we looked at in Ringrow. All right, and in this case, it was ultimately held that the clause wasn't a penalty. So the fact that the liquidated damages sum was made up of different figures for the different things specified in the clause was fine. Okay, so that wasn't an issue. And just because, hang on, what have I got here? So, the clause isn't a penalty merely because it exceeds the loss a little bit. So just because it's out of proportion to the loss a little bit, that doesn't mean that it's a penalty, because that doesn't meet that standard of extravagance, okay? So the stipulated sum may be more than the actual loss suffered, and it's only when it becomes out of all proportion or extravagant as determined by looking, just the dog, as determined by looking at the contract at the start of the time when the parties were contracting. It has to be that, it has to have that extravagance. Anyway, that's what we'll say. So the fact that it's merely higher than what the loss was actually suffered when that breach occurred is fine, as long as that extravagance isn't shown or unconscionability. So it doesn't just have to be proportionate, because remembering from Ringrow, the test isn't proportionality, it's whether it's out of all proportion. And here it wasn't. Therefore, the clause wasn't a penalty. Therefore, the clause was enforceable. Whew, okay. All right. So let's go through the case reading questions now that we got that out of our system and my dog has stopped barking. All right. So in terms of the first question here, so what factors or tests does the court use to determine whether a clause is penal or a genuine pre-estimate of damages? Okay, so with regards to this is the test in the AMEV and UDC, UDC4 case, and it's referred to in the reasoning. And the test is one of degree, and it will depend on a number of circumstances, including, okay, and then there's a list of factors. The first factor, the degree of disproportion between the stipulated sum and the loss likely to be suffered by the plaintiff. So that's that genuine pre-estimate kind of principle that comes through in the Dunlop case quite strongly. And then looking at the difference between the stipulated sum and the loss likely to be suffered, that's one of those factors that's relevant to the oppressiveness of the term to the defendant. And then second factor that you can look at is the nature of the relationship between the contracting parties. And that factor is relevant to unconscionability of the plaintiff's conduct in seeking to enforce the term. And then the test goes on to state, however, an agreed sum is only characterised as a penalty if it is out of all proportion to the damage likely to be suffered as a result of the breach, and if it is extravagant, exorbitant, or unconscionable. Okay? All right. So in terms of the next question then, so what presumptions apply, you can have a look at Justice Brennan's judgment on this, where it's stated that if the stipulated sum is payable on the occurrence of any breach of the contract, whether serious or trifling, there is a presumption that the clause is a penalty. Okay, so which facts did Mr. or Mrs. Plessnig rely on to argue that clause 6 was a penalty? You can see Justice Gaudron's judgment on this. So the matters which are said to constitute the clause being a penalty are 4 in number. The first one is that the clause makes no provision for refund to the respondents of any surplus arising on resale of the goods. So that is, in circumstances where there's that unjust enrichment, so the party gets more than what they make a profit, out of that breach. So those circumstances might go towards the clause being a penalty. The second factor there is the clause allows for the crediting of the wholesale rather than the resale value of the goods. The third is a clause providing for payment of loss of bargain damages in relation to a hire purchase agreement other than in consequence of a repudiatory or fundamental breach. So that is a penalty, or that goes towards it being a penalty. And the fourth factor, or the fourth matter, is a clause providing for payment in the event of early termination of a hire purchase agreement is not a genuine pre-estimate of loss of bargain damages unless it takes into account the duty to mitigate loss. All right, so that's Justice Gaudron's judgment there. All right, so in terms of question 2 then, so what if breach is penalised under the contract not by a clause requiring payment, but by a clause denying the breaching party a refund? You can see Justice Wilson and Tui's judgment for this scenario. And they state, this is a quote, so finally we should mention a proposition advanced for the appellant that the doctrine of penalties can only apply to clauses which compel a party to make a payment. That doctrine, it was said, can have no application where the complaint is that a clause fails to recognise an entitlement of some kind to a refund. However, even if that proposition be correct, as to which it is unnecessary to express an opinion, so it's still open on this, it does not follow that no relief is available in such a case. It may be, for instance, that equity will grant relief against forfeiture of the excess at any rate if the hirer has a proprietary or possessory interest in the property. Okay, and then the judges say this is an area into which there is no need to stray. So essentially, if the doctrine of penalties doesn't help someone in this scenario because it's unclear whether it applies in this type of scenario, in this instance, equity might step in through those principles around relief against forfeiture, and relief against forfeiture being outside of our considerations in this part of the module. So I don't need to say anything else about that there. But yeah, just know equity may step in. Okay. All right. So the next question we've got then According to Brennan, how do repudiatory breach and non-repudiatory breach generate different damages? So under the general law, a party who breaches a condition in a contract or who commits a fundamental breach of or repudiates a contract, a party who commits what I shall call a repudiatory breach. Oh, by the way, I'm reading from the judgment. Which, if you didn't realize that, this would make no sense why my sentence is so long. Sorry, I'll continue. A party who commits what I shall call a repudiatory breach is exposed to the loss of all his future contractual rights and to liability to compensate an innocent party for loss of the bargain. So that repudiatory breach means that it's the loss of the whole bargain as opposed to just the loss of the breach itself, if that makes sense. And then Justice Brennan goes on to say, but a non-repudiatory breach does not expose the party in default to that liability in the absence of a stipulation to that effect in the contract. So it's just looking at whether you're compensating for the loss of the breach itself or for the loss of the entire agreement. Okay, so that's that difference. So have a look at paragraph 144 for that discussion there. In terms of question 5, so what is the difference between loss flowing from the breach and losses flowing from the termination? That goes to that same thing. It's whether you're only looking at the loss of the breach itself versus the loss of the agreement as a whole, okay? In terms of the second part of that question, when is each used to determine damages? What is the incongruity pointed out by Brennan? So Justice Brennan states that in the light of these observations, which are the observations that we discussed in relation to question 4 there, in the light of these observations, I take the law to accept an incongruity in holding that an owner's damages at law for a non-repudiatory breach are limited to those losses caused by the breach alone, while holding that a clause which imposes a liability on the hirer to pay the losses caused by exercise of the power to terminate a hiring on breach is not a penalty. It may be appropriate to reconsider this incongruity in some later case and to canvass the correctness of some earlier decisions of this court. I'll leave. All right. So number 6, what did the court say about the reasonableness of Esanda limiting its potential reimbursement in the event of a breach to the wholesale value of the prime mover rather than the retail price? Just have a look at Justice Brennan's judgment around 149 for this. Justice Brennan states that as the owner is a finance company which outlays money to acquire goods selected by the hirer and is not a retailer of the goods, the best wholesale price obtainable in repossession cannot be said to be an extravagant and unconscionable underestimate of what the owner is likely to obtain if it sells the goods after termination of the hiring. Okay, so I will finish there, I think.